Thanks everyone for taking the time to join today. My name is Marla McCowan. I'm the training director for the Michigan Indigent Defense Commission. Today is our third and final session of our series covering best practices for complying with the MIDC standards. Today we're talking about Standard 4, counsel at first appearance and all critical stages of the proceedings. Regional managers Kelly McDaniel and Nicole Smithson are taking the lead today covering this material. So I'm going to go ahead and turn it over to Kelly.
Thank you, Marla, and thank you everyone for coming today. Just a few reminders as we get started. As Marla indicated, all of the PowerPoint slides are in the handouts, so you don't have to worry about getting everything written down as we're going along. Also included in the handouts are over 30 pages of resource materials and links that Nicole has done a fantastic job putting together for you. If you have any questions throughout the presentation, please put those in the chat. And Marla and the other regional managers are available to answer those as we go. I will apologize in advance if I speak a little fast. I'm prone to do that, but Nicole has also let me know that there will be severe consequences if I run over, as she has lots of good material to share with you. And I'm not going to lie, I'm a little afraid of Nicole. So we'll get started. Okay, the objectives for today's training are to increase your knowledge of Standard 4's requirements, to learn best practices for counsel at first appearance, and to discuss how you can help your client succeed in court and ways to learn and share your client's story and other financial considerations. Standard 4, as I'm sure we're all familiar with now, has two parts. The first part, I will be presenting best practices on counsel at first appearance, or CAFA, mainly at arraignment, and Nicole will share best practices for counsel at all subsequent critical stages. As always, more information on Standard 4 and any of our standards and practices and policies can be found at our website at michiganidc.gov. So how does counsel at first appearance make a difference? There are many instances where you will be the first person your client has talked to since their arrest. One of the big problems we have in this modern day of technology is no one memorizes phone numbers or addresses anymore. If I were put into jail, I would not have anyone to call because I have nobody's phone number memorized. An example is an attorney search social media sites while interviewing his client to contact his client's family and get phone numbers for the client to be able to call them. This was a domestic violence case with a no contact order, and the attorney was also able to contact a friend of the client's via social media who agreed to allow the client to stay with him after his release. This information and the address were then also shared with the court and used in the bond allocation later. We have an example of one client who was so worried and frantic because her children were left with her abuser after she was arrested. She was so distraught that she was unable to focus on her case and really help the attorney at all. So the attorney reached out via Facebook to the client's mother and was able to determine that the children were in fact safe with the mother. And she was able to relay that information to the client. The client was then able to focus on her case and actually help participate in the interview to allow the attorney to make an informed bond request. Not surprisingly, the most significant impact we see is with in-custody clients. We know that people who are detained for more than 24 hours are at a greater risk of losing their job, losing their housing, losing custody of their children, having medical care or medications disrupted, having mental health services disrupted, and sustaining damage to their family and community relationships. For those that are in custody versus out of custody for the entire pretrial period, the in custody are 4 times more likely to receive a jail sentence, 3 times more likely to receive a longer jail sentence, 3 times more likely to receive a prison sentence, and 2 times more likely to receive a longer prison sentence. Multiple studies show that counsel at first appearance works. Here in Michigan, there's a pilot project in Ingham County in 2014 to 2017. It showed a 28% reduction in the length of time between the arraignment and release. So what can counsel at first appearance do? Most important thing it does is gives people meaningful bail hearings by presenting relevant facts and arguments. Many times the attorneys can take this opportunity to call family members or guardians of those with mental health issues, have them appear on Zoom if possible at the arraignment, which shows the court that the client will have support if released. One example that I've seen is an attorney who arranged for the client's mother, who was also his caregiver, to appear at the arraignment. The attorney was able to inform the judge that her client had support, had somebody at home that was looking out for him, taking care of him, and had assured the attorney that the mother had assured the attorney that she would make sure that the client continued on all of his medications and would appear at all future court hearings. Counsel at first appearance also can stop people from making incriminating statements during court hearings, ensure that people understand their rights, especially their right to remain silent, and prevent uninformed guilty pleas just so the client can get out of jail. So let's talk about some best practices for counsel at first appearance. In this segment, we'll share examples of best practices. While all examples may not be practical in every situation or in every court, our hope is that it will lead to more attorneys thinking outside the box with a client-centered focus. The first step is the pre-arraignment consultation. And I use the word consultation here to not confuse it with standard 2's initial interview. During this stage, the attorneys will explain the procedure, what it is, probably more importantly, what it is not. Mainly, it's not the time for your client to tell the court his or her side of the story. Review all charges and potential penalties. And we recommend for best practices to use a form or a checklist. This serves two important purposes. The first one is it really helps focus the questions that you'll need answers to for your bond request. Questions such as employment. One example is that the client's request, he was worried about losing his job. The attorney contacted the client's employer during this consultation on the phone and to let them know that the client would not be there for work that day, and was assured by the employer that if he was released on bond, that he would still have a job to come back to. The attorney was then able to share that information with the court and obtain a personal bond. Other questions such as housing. One attorney learned that her client was homeless, had nowhere to go upon release. They called a local shelter during the Zoom consultation and confirmed that there was a bed available. They had the address, and then they shared that address, temporary address, with the court and were successful in obtaining bond. In this area, all of the attorneys that practice, do the counsel at first arraignment schedules there, they all have the local shelters on speed dial on their phones. And this is a practice that they use very frequently to make sure that they have a place for the client to go upon release. Other questions such as ties to the community. How many years have they lived in the community? What sort of family, job, church ties they have to the community, etc. This is also an area where you can note any red flags. So if you're not the attorney that is appointed to the case after arraignment, every jurisdiction does it differently, have a process in place to share pertinent information with the appointed attorney. Information such as any mental health issues that have been identified. If the client's been picked up on a warrant, let the attorney record know that the client is in custody and has been arraigned. If a tether is ordered, let them know that they are in custody pending tether so they can follow up on that. Let them know if there's any medication or medical needs that will require follow-up on. As we know, there are some medications that jails will either not dispense or will not dispense in a timely manner and have to wait through processes to get that. So one attorney who had this problem called the client's mother, was able to get the mother to take a picture of the pill bottle with the prescription on the outside of it, text it to the attorney. The attorney then looked up the medication, found out the standard uses for the medication, which verified the client's story, and also was able to access information on the severe withdrawals of the medication if the medication were discontinued and not routinely administered. And they shared that with the court and were able to obtain a personal bond for that individual as well. I'd like to take a few minutes to talk about the location of the pre-arraignment consultation, because there's always a little question about whether or not this has to be confidential. So the location for these consultations, the white papers for standard 4 from the MIDC state that a consultation is spaced that is semi-private, but where steps are taken to ensure that the conversation is not overheard, meets the standards requirements. So here for a standard 4 consultation, we know that it can be semi-private as long as it's clear to the client that it is not confidential if it's not in a confidential setting. So again, I want to make sure this consultation should not be confused with a standard 2 confidential interview after appointment. If you missed last week's best practices training on standard 2, please take a few minutes to watch the video. My colleagues Melissa and Barb did a wonderful job going through all of the best practices for standard 2. And the link to all of those videos, as Marla indicated, can be found in the email sent to the participants and also on our website. But there are some situations where what if that pre-arraignment consultation is also the standard 2 initial interview? Can it be both? Yes. In some jurisdictions, especially in a lot of the district courts, we find that the attorney that's appointed at arraignment is the attorney that will continue on with that case. So in those situations, that interview becomes the initial interview under standard 2, and it must be in a confidential setting. So there's a district court in Wayne County that does this. They have vertical representation. The person there at arraignment is the person that is there throughout the pendency of the case. And so in that situation, they make arrangements where they have longer time allotted for those interviews because it is essentially the initial interview. And when they do that, what happens is they found that many of those misdemeanors can be resolved at the arraignment stage. One unique way this court has dealt with having the arraignments and not having the prosecutors available at the arraignments is they have a written memorandum of understanding from the city prosecutor in the court. And that memorandum outlines what cases that they will automatically allow a plea on. So it lists the charges, what the allowable plea is, and then it lists the exceptions of, they wouldn't allow a plea if these facts or circumstances were present. And with that, they've allowed, so most of those cases can get resolved at arraignment and the plea can be taken and put on the record, even if the prosecutor is not present. So that's one creative way that they have found to work outside the box to help their clients. So I want to spend a couple minutes on this slide because there's a lot packed in here. So we have some sample forms I'm going to talk about, and those are available in your handouts as well. These forms are kindly provided by the Misdemeanor and Felony Defender Office in Detroit that does an amazing job in the busiest district court in the state. This office handles all of the felony and misdemeanor arraignments, and they continue on with some of the misdemeanor docket after arraignment as well. So included here that they've shared with us is an information sheet. This sheet is a one-page piece of paper that is handed out to every detainee in the Detroit Detention Center. It includes next steps. It talks about the process, the procedures, where they are now in the legal process, what the next steps are. One interesting thing that has come up during this is during COVID, the deputies quit allowing any pieces of paper to be transferred or given directly to the detainees. So these attorneys, this attorney group has worked on creating a video that can be played on a continuous loop in the hallway so they can see this and watch this as they're waiting for the arraignment process so they can still get the information to them. The sheet also goes through and details the bond types, gives description of each type of a bond, explains what a personal bond is. And I know we've all been in court or had clients where the judge says that it issues a $5,000 personal bond and the client is very upset and objects because they don't understand that they don't actually have to pay that in order to get out of custody. So this is extremely helpful. The sheet also gives them information on how to access the court website to follow their case throughout the pendency of their case. It also has links to 2 amazing videos that are just really impressive. They're short, they're 3 or 4 minute videos. One video on there is a step-by-step case, a look at how to look up a case on the court website. So it shows them how to get onto Google, how to find the court's website, how to look up their case, how to search and get information for their case going forward. The other video is how to use Zoom. It takes them through how to use Zoom, how to link on, how to get on, whether it's on a tablet or a phone or a laptop. The links to these videos are in the handouts as well. But take a few minutes and look at those. These are something that I think is something that could easily be replicated or referenced to, and I think make a big difference for the clients. The next sheet that's included is an arraignment intake sheet. So this is the form that they fill out with every client that they meet. They use the notes from this form and during the arraignment itself. And also this is where they make notes if there's any information they need to share with the appointed attorney going forward. They provided a sample of a request to set aside a KPS bond and a sample of their emergency motion for reduction of bond. The emergency motions, a lot of these they will fill out in handwriting. And so what they've run into a lot of times is the magistrates, if a judge has set a bond because of a non-appearance, the magistrates are not allowed to change or alter that bond. And instead of just accepting that as the status quo and worrying about bond at the next stage, the attorneys in this group will actively go and they'll fill out an emergency motion for reduction of bond. If time doesn't allow, they will handwrite it. They will email it, text it, or walk it up to the other floors and ask the judges that set the initial bond for reduction in bond. And they have been very successful. They've received there was some pushback in the beginning, but I think the judges have realized that this is a process in place and that they're here to stay, and this is kind of the new normal there. So it's a fantastic, and they've been able to get a lot of those bonds reduced where their clients would have otherwise just stayed where they were. All right, so let's talk about bond for a few minutes. A couple of things with bonds is best practices. Don't just ask for a personal bond. Provide that additional information to support the request and highlight any of the factors from the Michigan Court Rule 6.106 F1 that would support a personal bond. And don't just ask for a reasonable bond. The 8th Amendment and Michigan statute prohibit courts from requiring excessive bail. Provide the court with some direction. Along the same line, don't leave bond to the court's discretion. This is the time for you to advocate for your client. Tell the court what it should do and explain why it's fair for that sort of a bond. The other thing to consider with bonds is tether options, time and expense with both of those. So in Wayne County, as there was typically before COVID, we would see anywhere from 2 to 3 day delay from a judge's order allowing release with a tether before they were actually outfitted with a tether and released from the detaining facility. With COVID, we saw that delay increase to 5 to 7 days. And so what the attorneys have started doing is that during the bond argument, they'll argue that because they wouldn't be released immediately, they're asking the courts then to release them with an order that they report the next day to the tether office to get outfitted with the tether. And this has been very successful. And also, if available, they've asked if they be released and allowed to report to a private tether company so that they are not delayed and still in custody during that time. Bond conditions. As we know, a lot of judges put as many conditions out there as they can. This is sort of the, throw the spaghetti at the wall and see what sticks theory sometimes, but always argue against any conditions that are not relevant to your specific case. Unless they are justified, conditions such as restriction for alcohol use, sobriety, monitoring, scram bracelets, no contact orders, weekly reporting, etc., should all be challenged. Michigan Court Rule 6.106, sub rule C, talks about the conditions for a personal recognizance bond are that the defendant will appear as required, will not leave the state without permission, and will not commit any crime while released. So 3 conditions. Sub rule D is the conditional release section. And it states that if the court determines that the release described in sub rule C will not reasonably ensure the appearance of the defendant as required, or will not reasonably ensure the safety of the public, the court may order the pretrial release of the defendant on the conditions or combination of conditions. So one of those 2 things must be satisfied in order for any additional conditions to be added. So don't just accept that as a status quo. Challenge those. If those conditions are not specific to your client or to your client's charges, then argue those. Guilty pleas at arraignment. While we see these mostly in misdemeanor court, just a couple tips to make sure that if the client's going to plead guilty at arraignment, that we've covered everything. So you should make sure you've reviewed the discovery. And the first step in that is making sure you have all of the discovery. Make sure you reviewed it very clearly and thoroughly with your client. You've had the opportunity to do that in a confidential setting. You must fully discuss the case and explore all possible defenses with your client. And lastly, just ensure that that conversation does occur in a confidential setting. This completes my presentation on counsel at first appearance best practices. I now turn it over to Regional Manager Nicole Smithson to walk us through some best practices for the other critical stages. Nicole? Oh, Nicole, you're muted. And one day soon, we can hopefully all quit saying that.
True, that would be nice.
Yeah.
Okay, so I was like so concentrating on, okay, here's how I'm going to share my screen that I forgot that mute button,
Yes.
but oh well. So as Kelly said, I'm the regional manager for Lapeer, Macomb, Oakland, and St. Clair counties. It has been called the best region, but you know. So today, let's get started by talking about ways in which you can help your client succeed at court. Stephen Hawking said that half the battle is showing up. And for a lot of our clients, showing up is actually most of the battle. Showing up can be getting to court can be extremely difficult for people. And so there's a couple of things that you can do to help them get to court, short of driving them there. First, you can remind your client about when they have court hearings and other important appointments in their case. You can talk to them about how they're going to be getting to court, and you can help them come up with a transportation plan. And you can also make sure that your client is aware of any kind of location change or location transition. So if the case is moving from district court to circuit court, or if the case is moving from one courtroom to another courtroom, that's the type of information that you can make sure that your client has. Next, you can also make sure that your client has a good understanding of what is going to happen at each court proceeding and what is not going to happen at each court proceeding. A few times I've seen cases where the defendant did not really have a good understanding of what could happen at the court hearing. And so the person had expectations that other things were going to happen and wound up having some kind of emotional reaction to the fact that what they thought was going to happen did not happen. And, obviously someone having an emotional reaction, yelling questions, making demands of the court, that does not lead to court success. Next, you can also make sure that your client is Zoom competent. As Kelly mentioned, we have some resources in the materials for you to help you with that. There's an excellent how-to video that the misdemeanor felony defenders made that we have a link to. And we also at the MIDC put together a tip sheet for clients to review to remind them of things like, dress appropriately, be in the appropriate location, have a power source near you. So hopefully all of these things help. Next, it's also very important that you insist on having confidential communications with your client off the record. I have observed several hearings where the defendant, without prior notice, is asked to decide whether to waive the 14-day rule. And, the attorney will say, oh, you have the right to have this hearing within 14 days. Are you willing to waive it? And it's like, no, that's extremely coercive to handle that question in that manner, because the defendant knows that the court and the prosecutor are looking for a yes. And it does not give your client the opportunity to also ask you any questions about, well, what does this mean? What are the implications of my saying yes? Should I say yes? So please don't have those discussions on the record. Instead, if you're on Zoom, ask for a breakout. And if you're not on Zoom, ask the case be passed. Finally, this picture on this slide is from a hearing that I observed a few months ago. I don't know about you, but all I can see about the defendant in this photo is that he's wearing an orange hat, he's probably male, and he's African American. This is not acceptable. Your client has the right to meaningfully participate in this hearing. And when he or she is not able to be seen, how are they able to use body language communication, express their humanity? I mean, this is very unfortunate. Now, MCR 6.006 does allow for remote proceedings, but 6.006D says that those proceedings must be in accordance with scale guidelines and requirements. And the Michigan Trial Court Standards for Courtroom Technology, specifically Section 2, Chapter 1B2, says that participants shall all be able to see, hear, and communicate with each other. So if you're in a situation where you cannot see, hear, and communicate with all of the participants, you should definitely object. Now let's talk a little bit about best practices for learning and sharing your client's story. And again, I would definitely recommend that people check out the previous MIDC trainings on Standard 2 and Standard 3. One best practice for learning your client's story is to try to develop your own cultural competence or cultural awareness. For example, in my culture, it is very important that people make eye contact, but that is not a universal human belief. So in my culture, if a person is speaking, if people aren't looking at that person, that's a sign of disrespect. And if a person is speaking and is not looking at the listeners, that is a sign that the person could be not telling the truth or could be being dishonest. Recently, I worked on a project with some Native American people, and one of the people who works a lot with non-natives said, I just want to let you know that eye contact is different with Native Americans. We like less sustained eye contact, we like less direct eye contact. And I appreciated her letting me know that, but I thought about that in terms of representation. So if I had a Native client and wasn't aware of the difference in eye contact, if I was talking to my client and my client wasn't looking at me, I would probably think that person didn't respect me or didn't want me to be their attorney. And similarly, if I said, hey, tell me what happened, and the person is telling me the facts of the case and is not looking at me, I would probably think that they were not telling me the truth. And if we take this a little further, if the other people in the case, like the judge or the pre-sentence investigator, have the same values that I do about eye contact, and if your client's not aware of that, then your client could be portraying a lack of interest, dishonesty, a lack of respect that really does not exist. And so it's important to realize what you are bringing into a situation from your culture, what your client might be bringing in, and what the other people involved in the situation might be bringing. Another reason why it's important to be culturally aware is that there can be serious cultural misunderstandings. For example, does somebody have a weapon, or is someone in possession of an important cultural object? So, knowing about people's objects, knowing about people's culture, and knowing about why certain things, matter to them, why they do certain things, can really clear up a lot of these misunderstandings. So I guess with regard to culture, I would say don't be afraid to be curious. If something strikes you as different, then, ask about it. Another thing that we, bring to our encounters with others is that can hinder our ability to accurately assess information is implicit bias. And the two worst things about implicit bias are, one, you probably don't realize that you have it, and two, it can be at odds with your conscious values and beliefs. Everyone's probably heard about the studies about implicit biases involving race and gender, but really you can have an implicit bias about anything, age, addiction, a particular neighborhood, the police. And basically what a bias does is use assumption to fill in facts or gaps in knowledge. So it is important to regularly check in with yourself to make sure that what you think about something or someone is the result of fact and not implicit bias. And I would really recommend that you check out this very short video that the ABA did about public defenders and implicit bias. And we do have a link to that video in our materials. Identifying mitigating information about your client early in the case is very important, as it may be able to help you with plea negotiations or seeking a policy deviation, as well as developing your theory of the case. Places in which you can locate mitigating information are from your client's family and friends, from your client's employer, and from your client's educational, counseling, programming, and medical records. When you're looking for mitigating information, you're basically looking for things that put your client in a sympathetic or positive light. And those could be things like their age or their disability, if that disability impacted their judgment or potentially makes incarceration dangerous for them, disadvantages and challenges in their background, external influences, meaning like negative influences, like did someone take advantage of your client's immaturity to get them to commit this offense, and as well as positive support. So, does your client have people now who can help them make better choices and keep them out of trouble going forward? Also looking for things like positive accomplishments that your client has made, work that they're doing to overcome their addiction, or work that they're doing in counseling, and any kind of certificates that they've earned or other achievements. When you're looking for mitigating information, you should be very creative and think about anything that explains why this offense happened and why your client's going to do better going forward. Now I'd like to talk a little bit about pleas. And I would say that pleas really are not a place to tell the story, but they are places to try to prevent a negative story from being told. So here's a few tips on pleas. First, try to keep the factual basis as narrow as possible, and really just try to make out the elements of the offense. You also should rehearse the plea with your client. I've seen many situations where the client attempts to use the plea as an avenue of trying to make themselves look better in the case, or of trying to deflect try to deflect blame about their behavior. I've also seen situations where the attorney has asked the client for more negative information than was necessary to make out the factual basis of the plea. For example, someone was once in trouble for having a dog at large, and the attorney on the case asked about the fact that the dog had bit a kid. And that kind of leads me to my next point, which is if your client doesn't have to plead guilty and there is a real possibility of civil liability, you really are better off going with a no contest plea. So don't forget about a no contest plea option. Also, consider intervening when the prosecutor tries to elicit facts that go beyond the elements of the offense. For example, I recently was watching a possession of drug paraphernalia plea, and after the defense attorney had established the elements of the case with his client, the prosecutor got the client to admit that the needle that was the subject of the drug paraphernalia was used to inject heroin 40 minutes earlier in their jurisdiction. So I'm kind of like, ooh, that's a more serious offense. Why are we talking about that? Next, the pre-sentence investigation is a great place to share your client's story. First, it's important that you prepare. Make sure that your client knows the types of questions that will be asked and the type of information that will be needed as part of the interview. It's a good idea to try to do a mock interview to increase your client's comfort in talking about the case and giving that kind of personal information. And you can review MCR 6.425 to get an overview of the contents of what should be in a PSI, just to make sure that your client is also aware of the type of information that the investigator is going to be looking at. If you are able to attend the PSI, which should be everyone in a felony case, and some people in those district court misdemeanors where the district court is open to this, you should attend the PSI. Your presence at the PSI is comforting for your client, and you can also do things like help your client remember things they may have forgotten or left out. You can also ask questions to clarify things that your client has said, and you can also try to provide additional helpful information. Finally, it's important that you review the PSI with your client. Just because your client may be able to read doesn't mean that your client has sufficient comprehension skills to understand what's really being said in this report. And if you review the report together, that gives you a greater likelihood of catching those mistakes. Every word in a PSI matters. So again, every word in a PSI matters. So you should definitely be prepared to challenge material in the PSI that is harmful to your client. And I mean, there's going to be a lot of information in there that's harmful, but what you can challenge. Information in the PSI can affect the jobs that your clients can get in prison. They can also affect the family members who are allowed to visit. So it's very, very important that the information in the PSI be accurate. Your failure to challenge information in the PSI leads to the acceptance of the information in the PSI as being true. And the key to information being in a PSI is that it should be accurate and relevant. So I guess as a side note, if you object about something and the court says, well, I'm not going to consider that, then you should ask that it be stricken, because if the court's not considering it, why is it relevant? One tip in challenging the PSI is that the investigator will typically use the police report to form their version of the events. Police reports tend to be very unfavorable, and also they frequently have a lot of mistakes. So if you have testimony from a prior evidentiary hearing that contradicts the police report, you should definitely argue that the court should use the information from the transcript as opposed to the information in the police report. And then also you should request an adjournment to get evidence to contradict the information in the PSI when appropriate. Again, every word in a PSI matters. Another great place to tell your client's story and package the mitigating information that you've collected is the sentencing memorandum. This is also a great avenue for challenging the scoring of the guidelines. Now, dealing with court assessments are very, very challenging for many people. Court assessments tend to hang over people's heads for a long time, and people are usually dealing with court assessments long after we consider the case to be finished. I'd first like to talk about ability to pay hearings. When a court wants to enforce a payment order or punish someone for not paying, the court's supposed to conduct an ability to pay hearing. A person is not supposed to be incarcerated for failing to pay if the person did not have the ability to pay and the person made bona fide efforts to acquire the resources to pay. Most people waive their right to have an ability to pay hearing, and they either plead guilty to a probation violation or guilty to a contempt. And this is often a mistake because the person really did not have the capacity to pay. And so when that's the case, they really shouldn't be incarcerated for it. A few tips. First, your client should bring documentation showing income, liabilities, and other information that they want the court to consider in deciding whether they have the ability to pay. Counsel should be familiar with the factors that the court's supposed to consider in an ability to pay hearing in 6.425. They also should be familiar with the 14th and 8th Amendment cases about ability to pay, and we have some resources about that and a list of some of those cases in our other resources in the materials. And then people should also think about viable payment alternatives, which we'll talk more about payment alternatives in a minute. But before we get to that, I just wanted to mention that in this type of a situation, start off by asking, why haven't you paid? And then what did you do to get the resources to pay? And if paying was not an option, or if it would have caused a manifest hardship to your client, like basically they wouldn't have been able to take care of their children or themselves if they had paid their court assessments, then the court really should not be enforcing the payment order. So let's talk a little bit more about payment alternatives. So payment alternatives involve adjusting the amount that the person owes, because the court does have the ability to waive some assessments. It also can involve granting a person a payment plan or modifying an existing payment plan to reduce the payments that the person has to make. And then I think everyone probably has also seen courts allow people to do community service as a payment alternative. But in one of the resources we linked to in the resources guide, a judge mentioned that allowing someone to complete their GED could be considered a payment alternative. So to me, that says that courts are interested in working with people on helping them do things that increase their earning capacity. So maybe while your client has their high school diploma or GED, you could say, you know, right now with their job prospects, they're not able to make these payments, but you know, if you give us more time, they'll do this bit of training, and then hopefully, you know, they can make payments in the future, or because they're doing this stuff to increase their earning capacity, you can, you know, waive some of the assessments. Now, this is a big one. If your client is not able to satisfy all of their financial obligations at sentencing, it is critical that they keep their current contact information on file with the court, and that they be diligent in reading their mail to find out if there are any show cause notices. As we've been saying, people are not supposed to go to jail because they couldn't pay their court assessments, but a lot of people end up in jail because they end up in jail when they didn't pay their court assessments because they wind up getting warrants. So when the court has a situation where a defendant has not fulfilled all of their financial obligations, they set the case typically for a show cause hearing or potentially a probation violation hearing. And then when the defendant fails to appear for that hearing, a warrant gets issued, and then eventually the defendant gets picked up on the warrant, and then they usually have to wait in jail until either their hearing or their relatives are able to post some kind of a bond, because I've never seen a personal bond get issued with one of these show cause warrants. Yesterday, for example, I was watching court and 3 people failed to appear for show causes and 3 people got warrants set. So, I mean, the question that I asked myself is, well, did they willfully fail to appear, or did they just not get notice of the hearing? And my guess is they probably just did not get notice of the hearing. Next, an important thing to keep in mind is that if your client is in a situation where their case is dismissed or they get acquitted, they're not able to be assessed attorney fees. So if you're in a situation where the complaining witness failed to appear and the case is dismissed, don't let the court impose some kind of attorney fee obligation on your client. Instead, object under this statute. And then the last financial consideration I wanted to mention is that if a person fails to pay their court assessments within 56 days, the court is able to add a 20% late fee to the assessment. First, that late fee that they add, it is totally waivable. So if your client can present good information later, then maybe the court would be willing to waive that assessment. But also a little trick, if the court did not set a payment date in the order of sentence, the 56-day clock does not start. So the court shouldn't be adding that fee, because basically the person never got notice that your stuff is due by this date. Now, that doesn't necessarily save the day. When that happens and you say, hey, you didn't give them a date, so you have to take off the 20% fee, then the court will set a date and that will start the 56-day clock. But hopefully your client will be able to pay something down. And so if they get hit with the 20% fee later, hopefully at least it's a little bit smaller than what it was originally going to be. Now that that concludes the end of our prepared remarks. We would like to make sure that everyone understands that the MIDC website is available and is a great source of information on the standards. You can get copies of the standards. You can get supplemental information on how to comply with the standards, as well as information from the training today, the training from last week, and the training from the week before. And if you ever have questions that you don't feel are answered by the information on the website, you should feel free to reach out to your regional manager for assistance. On the website, we have a little map, and you can look and see which county you're in, and that will tell you who your regional manager is. And we are always happy to talk to people and help however we can. So does anyone have any questions for us, or does anyone have any best practices that they would like to share?
Nicole, I'm wondering if we can go back to something. It was kind of at the tail end of your presentation here. You don't have to share the slide again, but
Okay.
you were talking about assessment of attorney fees after when a case is dismissed, and that there is no authority for that. And I just wanted to underscore that. And I'm wondering if you could spend just a couple more minutes talking through that piece, because I think that that's really important. What we're seeing in many places is, there are loads of backlogs due to COVID right now, and cases are being resolved, right? And in some cases, very favorably resolved. They're being, dismissed or even turned into a civil infraction, right? But then sometimes attorney fees are being assessed. And I think that there's just sort of what's happening is that there's just a lot of stuff going on, and maybe people are just missing this. This isn't like sort of willfully or even just like agreeing that the attorney fee should be. So I'm wondering if you could go through a couple of tips, things to listen for, and if that is assessed, what somebody can do, what an attorney can do to get that removed.
Okay, so we actually received, so the reason why this issue really came to my attention was an individual was in a district court in one of my, in my region, and he had his case dismissed, but the court had assessed a $600 attorney fee, and the court was basically show causing him about not paying that fee. And so in that situation, we wound up kind of talking with the court and just educating the court on the statute, and the fee got waived. But really, what should happen is, the case gets dismissed, the court says, oh, we're gonna assess a $200 or however many hundreds of dollars attorney fee, and the attorney should say, objection, Your Honor, that fee is not allowable under MCL 768.34, because this is a situation where the person basically has not been convicted of an offense. And there is some language in the statute which talks about the person being a prisoner or under recognizance. And so I did some research on the under recognizance part. I'm like, does that mean that if you paid a bond that you can't, get the benefit of the statute? And I don't think that's the case. I think under recognizance basically can mean any kind of recognizance, which could be having paid cash, or could be a personal recognizance. But if the court was, going to dig in on that, then I would say, well, I would refer you to 769, I think it's MCL 769.1K, which talks about when the court can make different kinds of assessments. And that statute really requires a finding of guilt or conviction.
So like, even just to clarify or wrap up here, even if the resolution is to a civil infraction, it's the same result, right? They can't be assessed.
Well, I would argue, yes,
Okay.
that they shouldn't be assessed, because that's not a conviction. But I don't think that there has been any case law about the civil infraction question. And so I'm not comfortable saying, oh yeah, this statute also prohibits that with civil infractions, because we don't have any cases that tell us that. But the argument could definitely be made that that would cover civil infractions.
And Nicole, would the same statute apply to cases where I just observed a court recently where the individual was determined to be partially indigent, and so the court at arraignment ordered a $50 a month contribution toward attorney's fees to begin the following month?
So contribution is a real mess. And so in talking with our friends at SCAO, the position of courts is that if the case is dismissed, funds paid as contribution are not refunded. So I guess what I would say is this statute would be a post-dismissal assessment, and contribution is different because it's a pre-dismissal assessment. I mean, I don't understand why it's fair to keep someone's money if they weren't convicted, but that's just the position that has been taken. Any other questions, or how about best practices that people want to share? I know that Fred made a really good point at the beginning of the hearing, or at the beginning of the CLE in the chat, where he said, if your client has mental health issues or physical health issues, you should definitely get permission to divulge that information to the court. And I think that's a really important thing to keep in mind. And Fred also pointed out that the information in the PSI is read by the parole board, and it's part of the evaluation for parole. So yeah, again, every word matters in a PSI. Oh, and then finally, Fred said, we argue that a cell phone is a necessity like housing and transportation. Results have been mixed. So that probably that's in response to ability to pay hearings where the court says, oh, you have a cell phone, you could have paid me, you're paying a cell phone. And I think Fred's making a really great point. So thank you for being the third presenter at this seminar, Fred. We appreciate your services. And we now give Fred co-presenter credit, and you will get the same compensation that we received. Your check is in the mail. How about other folks? Do other people have any ideas about best practices or questions about anything that we've talked about or anything that we didn't talk about?
To the extent
Yes.
we're going to adopt a practice of keeping mental health conditions private, a more innocuous way of getting that information that we need to be careful about is asking someone for their list of medications. There are certain medications that are only used for psychiatric conditions, and if they're listed, that would be a disclosure to anyone who really knew what they were doing about a health condition.
Right, that's a great point. And I guess I would just build on that, like knowing whether your client has a mental health condition, even if they don't want it to be shared as part of their story, it's important for you to know, because you need to know, do you need to make accommodations during your interactions? Sorry, the chat was blowing my mind for a second. So yeah, do you need to make accommodations during your interactions? And are there other things that you need to do in light of that information? Now let's see what this chat says. Okay, can I get a link to the SATO guidance? Probably 40% of the people who are working have some ability to pay. It was the language of the statute that it had to be returned that caused me to stop discussing contribution. Retained attorneys under the same circumstances do not refund the money. Any practice that puts an indigent defendant in a better position than a defendant who retains creates its own set of problems. So yeah, that is that's a very thoughtful point. I don't have a link to any kind of written material on contribution from SCAO. That's just information that I received from talking with someone at SCAO, particularly when we were working on the indigency standard. So unfortunately, I cannot help with materials on that.
I just had a comment about your investigator's version of the offense in the PSI. I thought your comments were very, very timely and important. That's probably the best thing to do, is to try to get something contrary. But I've run into situations where judges and certainly prosecutors will say, well, you can't strike that information from the police report because that's accurate. That's what the police officer wrote. In other words, you can't, shall we say, edit or redact the police report. And the only fallback position I've had is to make an additional statement under the defendant's version. So even if the judge says, well, I'm not going to consider that, say, well, Judge, we'd like to add this to the defendant's version. And then, you know, whatever we're saying is contrary to what's in the police report, at least gets in the document. So those who look at it later can actually see it. Just a thought.
Yeah, that sounds like a great tip. Thanks for sharing. Oh, looks like we have something in the chat. Oh, okay, that would, let's see.
I think some of it's around guidance. You know, there's some individual things. We talked about the cell phone already, and you know, paying for cigarettes, and you know, there's some other factors which seem pretty random and potentially irrelevant that judges are globbing onto here. I'm wondering if you could speak to, I know the indigency screening standard has all the considerations, right, that's proposed on our website. To the extent that those are factors that people should be able to use right now. I'm just wondering if you want to talk about that, Nicole.
Yeah, so our indigency standard does not bind the courts, but I think that you could use our indigency standard to try to be persuasive with the courts. And so, you know, I mean, the issue with smoking is tough, but I think that for some reason, my brain is telling me that there may be something in bankruptcy law about smoking and smoking being, you know, an acceptable expense. Like just something saying, you know, just because someone may have to smoke doesn't mean that they shouldn't, you know, fully qualify for bankruptcy relief. I need to think that out more. I'm sorry, I wasn't prepared for that question. But as far as our indigency standard goes, yes, our indigency standard, I feel, is very favorable to defendants. And I think that, you know, you should look for similarities between your client situation and situations that are spelled out in the indigency standard, and, you know, use that to try to be persuasive authority.
And that
Anything
standard,
else?
like all standards, is on our website at michiganidc.gov. And that standard, the indigency screening standard, was recently fully approved by the Department of Licensing and Regulatory Affairs. So we are going to be looking towards planning for compliance with that standard from systems in later this spring, and looking to about a year from now have it incorporating full compliance with that standard. This has been a really great session. Thank you so much. I learned a lot, and I hope everybody also enjoyed the information that was covered today, as well as in our prior series as well. If you missed any of them, they are available on our YouTube channel. We created a playlist for all three of these. After the recording today, I'll upload this to our YouTube channel as well. Hopefully you enjoyed the series. I know I sure did. We've gotten a lot of great feedback so far. So thank you everyone for joining and for the feedback that you've given to us. You will get an evaluation if you haven't gotten it already. You should have gotten a message at about probably about 10 minutes ago or 9 minutes ago with a link to provide us with some feedback with the evaluation, as well as the CLE form. I mentioned this already before, but everybody is entitled to claim some CLE credit for attending these sessions. So if you join live or if you want to go back and watch the video, you're on your own, you know, for recording that and keeping track of it, reporting it to your system, or sending that form into us for tracking. That will also be a part of that message that you received today. If you didn't get that, you can come back to our website. We're going to post the link to this series, as well as all of the materials, the CLE forms, and we can answer any of your questions that you have. Again, just check it out at michiganidc.gov. And thanks, everyone. Thanks especially today, Kelly and Nicole. This was really great. Thanks to the whole regional manager team. I see a lot of you on here still on my screen too. Thank you everyone for all of your work in putting this together. This has just been really tremendous, and I appreciate it. And I know everybody appreciates the information that we got on best practices for complying with the standards. Have a safe weekend, everyone. Bye-bye.